modern technology. Labor saving devices. Saves you for doing any labor. University aided IT. Yeah, we're not going. Such a headache. Number of times I have flown to DC, 2-hour meeting, turn around and fly back. It's like, really? I have to do that?
Okay.
With the microphone. Oh, yeah.
All right, let's bring this meeting, call it to order on January 26th, 2024 at 9:05 a.m. First item is a roll call. Please answer here. Dr. Bazzini?
Here.
Dr. Coble?
Here.
Mr. Daniel?
Here.
Dr. Downing?
Here.
Dr. Drake?
Here.
Dr. Kerrigan?
Here.
Mr. Parsons?
Here.
Ms. Emick?
Here.
All right. Everyone's here and accounted for. Second item is to review and adopt the minutes from the last meeting. Is there a motion to accept?
One thing before we go ahead, for the commissioners who are participating via Zoom, when motions are taken, can you please raise your hands like old school, physically raise your hands, not the Zoom hand? And don't use a voice vote. We just need to be able to see your hands up. That's the most efficient way we'll get through it. Thank you.
Okay.
And for the individuals present here, you kind of have to be on top of the mic for it to project in the room.
All right, so we're back to the minutes from the last meeting. Is there a motion to accept the minutes?
Motion to approve.
Is there a second?
Second.
All those in favor say aye.
Aye.
Opposed? Motion carries. Next item is the administrative update.
In your materials, we have an updated budget spreadsheet. We're happy to answer any questions about that, but I don't think any action needs to be taken on it. One of the issues that we've been working on for a very long time, as you know, is the Commission's public-facing database, which has 6 different elements to it, and it has taken quite a bit of time. We have launched the OSAC page, or OSAC standards implementation section, the accreditation profiles section, the licensee section, but we're still waiting on complaints and disclosures, filing, and public-facing information regarding that, as well as the QI section. So I have asked a representative from the Office of Court Administration for our next meeting to come and give us an update, because as Mr. Daniel has pointed out to me recently, it's been 3 years and in April, and Mr. Daniel gives many talks around the state and is projecting that we're gonna have this thing up and running and it keeps getting delayed. So I think what we're gonna do is ask OCA to give us a sense of what a path forward on that database looks like. And having spoken with the administrative director, she is going to be, I think, she will have much more information for us at our next meeting. And I have all confidence that she's directing attention to expediting the resolution of that. So we will have an update from them at the next meeting.
All right. Any further comment on that? All right, next item 4, the complaints and disclosures. Mr. Daniel?
Yes, sir. Thank you, Dr. Bernard. We have today one holdover disclosure from our October 2023 meeting. We have 8 new disclosures and 2 new complaints. And just for clarification, our disclosures committee meeting did not meet yesterday, as it sometimes does. It's been a while because we're simply not enough matters to justify that. The complexity sufficient to justify meeting. Our first matter is item 23.18, the City of Austin Forensic Department, Firearms and Tool Marks. This was reviewed at our October meeting. It concerns a number of matters, a myriad of issues, quite frankly. It stemmed from a firearms analyst releasing a PowerPoint presentation without prior technical administrative review, and then they found some other issues, an incorrect and conclusive conclusion. They found some allegations of training being insufficient. She actually resigned in July of 2023, and there was another issue with regard to some physical evidence in her storage locker, personal storage locker they found from ranging literally over almost a 2-year period. But without belaboring all the number of issues, our staff has reviewed this carefully and had a good solution, at least at this point in time, that number one, the lab had done a very sufficient job as far as their analysis and their corrective action. But Ms. Garcia and I discussed yesterday possibly recommending that a consultant be retained to perform a review of the department's firearms and tool marks section, including their current training, maintenance and adequate contemporaneous training records, and sufficient for compliance with accreditation. I'm prepared to make that in the form of motion. Ms. Garcia, we probably should include some recommendations as to 2 or 3 people that would be qualified to do that.
So for this one, I think what we're recommending is that the city retain an expert and report back to us on their findings.
Okay.
So I'm not sure that we need an investigative panel. If what they bring back merits it, then at that time, I think we would create a panel.
Let me go and make that in the form of a motion.
All right, motion has been made that the City of Austin Forensic Science Commission retain an independent subject matter expert to then evaluate their training program. Is there a second?
A second.
All those in favor say aye.
Aye.
Opposed? Motion carries.
Which brings us to our second matter. It's item number 2340 that comes out of the Houston Forensic Science Center, Forensic Biology Unit. I think Ms. Zemak is going to recuse herself from this. Is that correct?
Correct.
And they had reported an incident in the biology DNA section where they become aware of rare instances due to just a very subtly present star mix of some probabilistic genotyping software used by the center. And it required a supplemental report to be issued with additional likelihood ratios on each and every cases. They found that applied to 3 previously reported cases from really back to January of 2022. On September of last year, they followed up with the corrective action of the matter and let the commission be aware that identified 3 other cases needing supplemental reports. It didn't sound like an overwhelming, pervasive issue. They had certainly taken required steps to correct and address. And based upon that, staff had made a recommendation we might just table this at this time, pending receipt of their final corrective action, and then direct staff to coordinate a STAR mix user training to discuss how laboratories address this issue. With that in mind, I would expect to make that as a motion this time that we table pending receipt of the final corrective action.
Mr. Daniel, we did receive it, but I have not had a chance to look at it because we've been preparing for the meeting. So I think that we can continue, but I did want to correct that we have gotten it.
I still would like to make a motion to table this time.
Is there a second?
I second.
All those in favor say aye.
You just had a second by somebody who accused themselves.
Oh, that's right.
I'm sorry.
Yep,
Thank you.
you're right, sir. Thank you. Is there a second?
I'll second.
Okay. All those in favor say aye.
Aye.
Opposed? Motion carries.
Which would also bring us to our next matter. It's our third item 2351, also from Houston Forensic Science Center, latent prints, APHIS section. I think Ms. Seamack's going to recuse herself on this also. Is that correct?
Correct.
And they had reported an incident in the latent print section. The FBI had notified the lab of a problem in the APHIS system, specific to where an area location filter is selected for both palm prints entered in the system. It essentially prevented the system from allowing the print to be continuously searched against new prints. They found out that it begun sometime back in 2014, literally 9 years before, and affected basically every customer that used this in the palm print area location. They don't believe there's a technical issue that caused this. Yet it was the software does have a technical impact on their casework. The laboratory was tracking the instance of corrective action and documenting mitigation plan. It did a research of all the affected prints and cases. The laboratory drafted a deviation memorandum from normal process workflow for each case file. That memorandum is now attached to each and every case record that comes out of there. They did report this to the district attorney's office down in Harris County. They also reported to the Harris County Public Defender's Office, along with defense counsel and other prosecutors in the area. They found out, they identified 92 cases that were researched and 20 with some new form of hits. Their reaction and responsive action has been pervasive. View of its corrective action, the lab explains the issue is outside of its control because they don't control APHIS, sure there's managed by FBI. And there's not a solution except to keep notifying, and that's what they intend to do. Based on all their corrective action, I respectfully recommend follow staff's recommendation, taking no further action given the analysis and corrective action by the lab.
Okay, we've got a motion for no further action. Is there a second? Second.
Second.
Favor say aye.
Aye.
Opposed? Motion carries.
Which brings us to our next matter. So our fourth item is from the Jefferson County Regional Crime Lab, Seized Drugs Department. Back in September, they had identified an incident in the seized drugs section. They had a power outage a year ago in January of 2023 with a manufacturer's default on a gas chromatograph of source temperature of 230 degrees centigrade, rather than being online, the laboratory's validated temperature of 280 degrees centigrade. The lab set about to check on 239 cases that had come through that incident. They notified all the stakeholders. They also adjusted the temperature. They also found that it did not affect the ion fragmentation patterns or cause any drug misidentifications, which is good. They've instituted new procedures to monitor that. Didn't sound like too huge and emotional, so staff at Perspective recommended we take no further action based on the root cause analysis and corrective action. I would make that form of a motion.
Is there a second?
I second.
All those in favor say aye. Opposed? Motion carries.
Which takes us to our fifth item. It comes out of the City of Austin Forensic Science Department Crime Scene Unit. A crime scene specialist back in September had been removed from casework. There's some quality issues by the lab. She learned that while preparing for a case interview with the prosecution team. They discovered two quality incidents from back in 2022 and a third minor documentation problem that occurred in August of 2022. The analyst had requested a voluntary demotion for some personal reasons, and the lab had reassigned her from the major crimes casework to property crime casework, also back in 2022. Summary of the issues can be that back in June of 2018, they had a case with one multiple fired cartridge case that could not be located. The remaining cases were actually entered in an item. It's simply an item of loss or missing evidence. It is disclosable. In June, there was a second matter where there were some photographs taken at a crime scene. They were deemed of insufficient quality by this specialist. Prosecution's office was notified. The third matter was simply an incorrect lab number where the person missed a digit. The specialist resigned after no longer works as a crime scene specialist or at the lab. It appears to me that certainly every step that he taken was taken, and all review was thorough. So staff had respectfully recommended action to us, take no further action in light of the stakeholder notifications and also the review of the matter, and the fact that the individual no longer works as a crime scene specialist with that department. I would respect to make that form of a motion.
All right, motion's been made. Is there a second?
I second.
All those in favor say aye.
Aye.
Opposed? Motion carries.
Which brings us to our sixth item. It comes out of the Barrett County Criminal Investigation Lab, Seized Drugs Section. They disclosed an incident back late last year, 2023, with two unexpected peaks in their seized drug section's performance standard, where it used a positive quality control check on one of the gas chromatograph and mass spectrometers. In November, the lab had identified the unintegrated peaks that pertained to benzoate, if I pronounce that correctly, testosterone, cypionate, if I pronounce that correctly. And they later identified an additional peak below the base of cocaethylene. They stopped work immediately until they determined the source of these additional peaks. They had unintegrated peaks that potentially affected 101 cases they had already done analysis on. They set about to determine the root cause. They found it to be pertaining to some contamination. The lab performed some tests on some blank solvents. They also tested some rinses. Identified the cocaethylene from the certified cocaine standard, the benzoate from, believe it or not, dishwashing detergent. The lab used 101 cases using the contaminated performance standard, found no cause for concern because the testosterone cypionate was detected and reported. They now attribute this to containers. The lab discarded all their 10 milliliter plastic graduated cylinders and replaced those with glass. They also prepared a new performance standard, verified the standard to ensure the new mixture did not contain contaminants. And they placed a memo in all affected cases and notified the prosecutor's office. There are also many procedures, including guidance when the performance standard is unacceptable. So it sounds to me like their response was thorough, robust, and in light of all the review conducted, the staff had recommended that we take no further action. I'm prepared to make that in the form of a motion at this time.
All right, motion's been made. Is there a second?
I second.
All those in favor say aye.
Aye.
Opposed? Motion carries.
Which would bring us to our seventh matter, just item 23.70 from the City of Austin Physical Science Department. Almost involves more of a personnel issue than the last issue, but the City of Austin Auditor's Office had found a former firearms analyst and also a department manager had committed some misappropriation. He used a city-issued pro card to buy some things unauthorized. They found 7 transactions that were in that category. The lab reported those findings to ANAB. They felt they should. The lab set about to review his casework and his quality records, which were responsible, could have affected his accreditation. Lab discovered early this year that all Austin Police Department drug cases completed by the former manager were retested, except one that was completed 2 weeks ago. It appears everything was in order and consistent with the original reports. The toxicology supervisor conducted a review of all 20 blood alcohol batches completed by the former manager between May of 2013 and May 2023, a 10-year period. They also reviewed all quality records by the manager from 2016 to 2017. Austin PD had reviewed some financial services team reviewed other purchases and found no additional questionable incidents. Staff had recommended no further action given the energy devoted to the review of the records and the review directed by the laboratory's accrediting body, ANAB. If they find something else, they'll report it to us, but at this time, in light of their review, staff had recommended the commission to take no further action, which I will make in the form of a motion.
Can I just interject here quickly, because there's a error in your memorandum. To be clear, the individual that the city auditor investigated for misuse of the pro card was the lab director, one step over the chief one step below the chief scientific officer, and actually his prior subject matter expertise was blood alcohol and seized drugs, to my knowledge. So I just wanted to be clear that one of the reasons why this P card misuse disclosure came to us into ANAB was due to the leadership position of this person, which was very senior, and for a time I'm pretty sure he was quality manager as well. So that raised concerns for us. Certainly the city had its own set of independent concerns, and ANAB as well, and that's why ANAB asked them to go through and look at casework too, because, to make sure that there wasn't any indication of misconduct there, so they did that sampling. And I think, what ANAB asked the laboratory to do, I thought was appropriate given the circumstances. I just wanted to clarify that.
Okay, a motion's been made. Is there a second?
I second.
All those in favor say aye.
Aye.
Opposed? Motion carries.
Which would bring us to our next matter, is item 23.71, comes out of Bear County Criminal Investigation Lab, actually Management Human Resources section. Not a criticism, but it sounds more like a personnel matter than a forensic matter, but nonetheless, early this year they disclosed the matter that a retiring employee had sent a memo to everybody who breathed oxygen. County judge, county manager, human resources, DA's office, everybody. And they had reassigned a drug chemistry supervisor. That supervisor responsibilities were removed. The departing supervisor had drafted a memo and titled it Use and Inept and Competent Management of Crime Lab, Practicing Forensic Science without a license. There were issues that supervisors would walk around and be heavy-handed in management, criticism about how he was replaced, and somebody took excessive amounts of leave. The memo also alleged that the director or assistant director held a forensic license and if they did certain tasks as delineated by their job description, they were practicing forensic analysis without a license. The director said, no, we don't, the license for analysts, we don't do that. So, laboratory reports, no corrective actions were anticipated out of the complaint. Really, it involved management style and human resources issues, employment of personnel. So, in light of that, staff had recommended we take no further action, which I very much agree with. Make that form of a motion.
All right, motion's been made for no further action. Is there a second?
I second.
All those in favor say aye.
Aye.
Opposed? Motion carries.
Our next item is out of DPS Westlaco. This is item 23.69. Late in November, they had discovered an evidence envelope, a 9x12 envelope that appeared to have some chewing or tears on the side of the packaging. The lab set about to review all the video and all the records pertaining to it. When all the dust settled, the consideration size and possible drug substance, they felt like it was caused by rodent activity. So what we know from this is Westlaco, they have rodents, and they may have happy rodents. We don't have any regulation of rodent activity.
I don't believe so far the legislature's not put that.
So
in our, we're saying.
okay, good. So in light of that, sincerely, we could be humorous about it, but the lab did do a robust review of it. Our staff recommend take no further action in light of their analysis and corrective action. I would make that form of motion.
All right, is there a second?
I second.
All those in favor say aye.
Aye.
Opposed? Motion carries.
And our next, that takes to our complaints. Our next
Mr.
item.
Daniel, can I interrupt just really quickly?
Yes, ma'am.
I think it would be wise if we afford opportunity for public comment, Dr. Bernard, for either of the next two complaints as we're going instead of waiting to leave.
We'll step out a little bit.
Oh, yes, right, so you can do the next one.
Right, that's fine, okay. Our next item of complaint is 23.63, comes from Chiquita Gibson. It's against Southwest Institute of Forensic Scientists, Science Gunshot Residue Section. I believe Dr. Norton accused himself. Okay. And I guess by way of summary, the complaint was made by Ms. Gibson on behalf of defendant Avery Cook. He had been convicted back in the 1990s. It involved something unusual. It had 3 co-defendants also in the same trial. All 4 participated in what are described the commission as a crime spree back in '94. There were written statements of each that described various crimes. In the case, the complaint alleged that the Southwest Institute of Forensic Sciences analyst Vicki Hall had inaccurately alluded to this person's involvement as a party of the offenses based on gunshot residue. It was a very complex case in light of gunshot residue being taken on all the defendants. And the lab reported finding antimony but not barium on 2 of the defendant's hand swabs. Another co-defendant had antimony and no barium on 1 hand. Ms. Hall offered some testimony, which is in our materials. It was extensive because they were all tried together. She was questioned by prosecutors about 4 defendants and then cross-examined by 4 defense counsel with different theories being put forward. There was actually the basis of a writ which got withdrawn, which is unusual, but staff made a recommendation that we table this pending receipt of additional information. Is that correct, Ms. Garcia?
Well, I do have an update, which is that we at this point have now spoken with both Cynthia Garza from the Dallas County CIU and Gary Udishin, who was the attorney. Robert did speak with him. Gary gave some explanation about the posture of the criminal case. And I think in light of what we also received an explanation from SWIFT's. And I think what the complaint sort of tried to analogize the testimony here to the testimony given in Richard Miles' case, which I know everyone is familiar with. But there were some real differences between what was done in Miles and what was done here, including but not limited to the fact that she was crossed by 4 different attorneys, and this was a co-defendants all tried together. What we did say to both Cynthia and Gary is that we were going to recommend no further action, but that if Gary, wanted to come back and ask us to reconsider it, the commission could always do that. But to not leave it lingering on the agenda.
Why don't we not table, why don't we take no further action, opportunity, if something substantial comes forward.
Yes, and Dr. Bernard will recuse.
So I'm gonna ask Seema to make a motion, we take no further action.
I'm gonna make a motion that we take no further action.
We have a motion on the floor, do we have a second? Second from Mr. Parsons. Motion on the floor, second, take no further action, all in favor say aye.
Aye.
Aye. Any opposed indicate by saying no. Ayes pass, and take no further action on that item. Which will take us to our last item of the day. It's number 2367. It comes from Tiffany Roy against a Tim Caliphate in forensic biology and DNA topic. And it was a case tried just a few months back here in Travis County. The state had sponsored a witness, Dr. Tim Caliphate from Sam Houston State University, to rebut testimony of the defense expert witness, Matt Cotaro. And he testified as in the trial. The complainant, Tiffany Roy, was an independent DNA analyst. They convicted the defendant of murder, and a motion for new trial was currently pending before the trial court. I think the complaint centered primarily around Dr. Caliphate's testimony that he reviewed the DNA case file, including the report by DPS, and agreed with the interpretation by DPS. His testimony might have gone a little bit outside of maybe his area of expertise, because he does kind of an activity level analysis about DNA profiles and be more likely to observe in this location, that location, and his statement was kind of a broad global, I'm comfortable saying that in my opinion, or something to that effect. So without further detail, the staff had recommended possibly accept this complaint for investigation, form a committee to review it, and then report back to the commission at the appropriate time after some work's been done. And I would like to make that form motion, accept the complaint for investigation, form an investigative committee.
Before we go down that motion path, I think there are a couple of clarifications that I'd like to make. And also we have 3 recusals for this because Dr. Caliphate is on the faculty at Sam Houston. So Dr. Spuccini and Kerrigan are recusing. Jarvis Parsons is also recusing because he has Dr. Caliphate as an expert in the case currently pending. In addition, Dr. Coble has worked on an NIJ grant and had other professional relationship with Dr. Caliphate. The complainant, Tiffany Roy, has waived in writing any concern about any potential conflict he may have, so Dr. Coble is not recusing. I did want to talk a little bit more about what it is that the commission would do were it to accept this for investigation. So this is not a case that we have jurisdiction for purposes of assessing professional negligence or misconduct. This is an independent expert who was brought in by the state to testify on activity level DNA analysis and interpretation. One of the reasons why this is an interesting case for the commission is that activity level analysis and testimony is something that's been going on in Europe, particularly in Switzerland, the Netherlands, also in the UK, and in Australia for quite some time. The national OSAC initiative, that I know you're all familiar with, is also in the process of considering how best to address activity level type testimony. And to just, for the non-scientists in the room, activity level testimony is really trying to answer questions that legal end users, including judges, may have on how DNA might have ended up on an evidentiary sample, as opposed to what traditionally DNA analysts, in particular in the US, have focused on, which is whose DNA it might be on the evidentiary sample. So this is very much cutting edge and new material for the US system. Dr. Califoot has been operating in this space for many years, I think a couple of decades now, working on this, and has his own research and publication in this area. The rest of the DNA community in the US, I think it's fair to say, has not yet received certainly any rigorous training at all on formal activity level analysis. And so what ends up happening often in court, though, is that DNA analysts get asked activity level questions often, like questions about cases regarding, just to throw out one example, when items of clothing are laundered together, when people live in a house together, what is the background DNA that might be present there? How DNA might transfer. In fact, we have an item on the agenda talking about the use of Sharpie in forensic biology screening, and what happens when that Sharpie might pick up DNA from a particularly saturated stain, and that DNA ends up, that profile ends up, or some portion of that profile ends up in other cases down the road. So these are questions that are of great interest to the criminal justice system. And so in my view, I think there are a number of observations. The three transcripts that we have in this case are the subsource testimony by the DPS analyst at DPS, which is the first time you see questions being asked around activity, and then you have the defense expert, and then you have Dr. Califoot's testimony. So all of those involve some level of activity questioning by the lawyers. And so really, it's sort of a perfect opportunity to make observations about how that all plays out in this case, and then also something that I'm particularly interested in is when one considers that this work is being done in Europe and Australia and has been for some time, there are some fundamental differences in the legal system there and here that need to be considered. There are many different things I think that the Commission can weigh in on this very hot topic in forensic DNA analysis and in forensic science in general. So I think we can be helpful. The first goal being to be helpful to the DNA analysts who are practicing every single day, doing their best to try to communicate clearly DNA results to end users in the criminal justice system. And it's a hard job. And so to the extent that we can help shed light on that, even if we don't have all the answers, which we won't, but if we can really help raise issues and shed light on what the key areas of concern are, give some feedback to the OSAC. I know they'll be listening for direction they can take when they are writing documents here. That is sort of the thought behind looking at this testimony with an eye toward both observations about what was done in this case and recommendations about how the community may proceed forward.
Thank you. In light of that, why don't I amend the motion to accept the complaint for investigation of open issue, this being a current concern of the guidance from the commission. And I'd like to take it one step further. If we
Mark,
were to
can you,
accept
thank you.
part of the motion.
Is there anyone who wants to speak regarding this before we move into?
1 second, we need the mic so that we can
Set
hear.
up over here.
Good morning. I am the subject of this complaint, and I encourage the commission to take this complaint on and investigate this. I think this is a timely topic. As has been said, it is a topic of high interest in the forensic community. I do have 3 points I would like to make. This issue seems to be turning into a conflagration of about 3 separate things. The first is allegations made that my testimony was not appropriate, was not done according to international guidelines, and was done with no support whatsoever. I use the case assessment and interpretation approach to help form my opinion. That has been in the peer review literature since last century. There are forensic practitioners alive today that weren't born when this was published and accepted by the scientific community. The second is that I started with somewhere around 3 dozen papers and narrowed it down to data that I thought was somewhat applicable to the circumstances of the case in question. And I used that data to inform my opinion. And all of my oral testimony meets the letter of the guidelines that exist, specifically the ISFG and the NC guidelines. The second issue seems to involve something that the expert witness has absolutely no control over, and that is discovery issues and when the court should be notified if a person is going to testify. I have zero control or input over that. I specifically asked and was specifically told that no written report was needed. But in an effort to be completely transparent, I provided a 3-page document that was essentially my entire working case file. I provided some around 6 or 7 specific references that I used to inform my opinion and a summary sheet of what in those references were relevant. That was made available to the court with my full expectation that that would end up being viewed by anyone who was interested. It's also, I would suggest, not incumbent upon one expert to somehow contact the opposing expert and let them know that they will be testifying. That's part of this complaint, that's in the written complaint. The third issue is kind of DNA testimony at large in the state of Texas, in the United States, and across the nation. And I agree that this is an issue that needs to be dealt with. I do somewhat dispute that this is a new issue. Activity has been a part of forensic DNA from day one. The very fact that we do a differential extraction because we expect to recover DNA from sperm cells implies an activity. Is it possible for DNA to get on an item that a person has not directly touched? That's an activity level inquiry at court. And that happens in every case, every day, all across this state, all across the United States, and all across the world. So it is a part of, and always has been, a level of inquiry. It is true that over the past 6, 7, 8 years, again, publications from last century have been rediscovered, and there's an awareness that we need to address activity level propositions. Strictly, we need to address the probability of the evidence given activity level propositions that don't come from the expert, They come from the parties in the case, or they come from the circumstances, the case information. That is starting to be recognized. And I think for that reason, this is a very important issue, and the Texas Forensic Science Commission should be a leader in our country and should look for ways to help improve this. But again, that has nothing to do with the words I said in my testimony at the trial that was the basis for this complaint. In my own way, I'm trying to help move the needle through teaching, through lecturing, through invited speaking events to prosecutors, to defense attorneys, to practitioners, through workshops that I have led, and I'm part of a team leading a workshop coming up in February. Finally, there's some concern that maybe this is the first time in the United States history that this has ever been done at court. I can assure the commission that is just not true. You can go to the appellate record and you can find numerous appellate decisions where an expert's testimony regarding DNA transfer, and that is problematic because we should be talking about activity level, not DNA transfer. But the appellate courts are full of decisions that support testimony when an expert has specifically said, you know, we did a validation study in my lab. I did a research project. I read some papers. It has been upheld time and time again. And what's probably of more concern to the Texas Forensic Science Commission should be that there are convictions now in the US that are being overturned at the appellate level because the prosecution did not explicitly deal with activity level propositions during the original trial. There's 2 in the state of Connecticut, there's 1 in South Carolina. You have access to that information. I have provided it to you. I sincerely hope that in the 30-some-odd year history of forensic DNA, this was not the first time that an expert supported their opinion by using the published literature. If that really is the case, I would suggest we have some problems in forensic DNA testimony. But I'm telling you that is not what is happening. This is nothing new. It has been going on since the beginning, and experts keep up with the literature. It actually happens to be my hobby these days. I spend my free time, such as it is, reading the literature and planning research studies. And thank you for your consideration and for listening to me this morning. And I actually, as a researcher, look forward to the next agenda item where you discuss an activity level study that is of interest to the commission. Thank you.
Thank you, Dr. Califat. I do want to clarify that I completely acknowledge and agree with Dr. Califat that people have been testifying about activity questions for a very long time, and there are court decisions about that. I think the approach that is taken in some other countries with a formal activity level assessment that incorporates reporting and elements of a laboratory's quality system and all of those things is not something that we have traditionally been doing here in the US system. So that's all I was trying to say. I think one of the great points in hearing the comments is that a lot of these questions really involve the intersection between science and the legal system. So if a witness is called on rebuttal, the attorneys may have a different understanding of what that requires or entails than what the scientists would prefer. We see that all the time in all different kinds of disciplines. So that intersection between the realities of the criminal legal system and the communication of science, I think, is always a fascinating subject and something that this commission has worked on for a very long time. So I do think there's a great opportunity here, and grateful that Dr. Califat gave us some food for thought.
I've asked to recuse myself from this complaint, but I wanted to follow on from something that we heard from Dr. Califat and from Lynn. You know, clearly the activity level.
Sarah, excuse me, you can't talk on it at all. You can't. If you're recused, you're recused. Sorry. Thanks.
Mark, how about if I restate the motion for purpose of clarification? The first motion would be for the commission to accept the complaint for investigation, review the testimony of the case, make observations and offer recommendations regarding activity, level of testimony in connection with the genetic testing. Being it is a issue of current concern among DNA labs, analysts, and certain court system. And I make that as the first motion.
All right, is there a second? I'll second it. All right, so all those in favor that can vote, say aye.
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 All right. All right, any opposed? Okay, motion carries.
And as a secondary motion to staff that committee, I would recommend the commission, make a motion that the commission nominate myself, Mark Daniel, Mrs. Emack, and also Dr. Downing as punishment for her not being here. Dr. Cole for him not being here today.
All right, so the motion has been made for the investigative panel. Is there a second?
Can I second?
Yes.
I second.
All those in favor say aye.
Aye.
Opposed? Motion carries.
I believe that concludes our complaints and disclosures.
All right. Next we'll move to the item number 5, which is an update on the research regarding the DNA transfer of Sharpie. It's very timely number.
I don't know, Dr. Koval or Ms. Seemack, if you would like to talk about the Sharpie project, that'd be great.
I defer to Dr. Como, but I will certainly add if necessary.
That's what I do.
Sounds good. Yes, so in your materials, we have a research proposal. This was between the research group at the Health Science Center, the CHI, and the Harris County Institute of Forensic Sciences. So our two groups have been talking about a plan for sort of getting a handle on how potential common this may be, how rare it may be. So we've put together a research study, and we just had a meeting on Wednesday to sort of go through again and refine a little bit more about the study. And again, it's if you recall, this was an instance where a cutting from an item of evidence was circled with a Sharpie, and the cutting went through the Sharpie on a recutting. It was after the initial cutting, there was another recutting of the material. And in that, there was a contamination event that was noted that this individual could not have contributed to this evidence because there was no relationship at all. So it turns out through the lab's quality system of looking for contamination, they were able to identify which case this came from, and they noted that it was potentially from the Sharpie. So that's the gist of what we're planning next, is to do a research study. It's part of your packet. We'll probably have a little bit of an update to that based upon conversations we had on Wednesday between Mickey from Harris County and our research group at CHI.
Thank you, Dr. Koval. We also have HCIFS here. I don't know if you wanted to add anything or is that?
I'll just give a thumbs up to
Yeah.
the progress.
Great,
Meetings are going well.
great. So we're excited to see the results of that project.
Can I comment on that as well?
Yes, Dr. Busini, you may.
All right, so I'm glad to see that there is a plan to move forward with a study on this particular topic. I also point out that this type of scientific problem is related to something known as activity level evaluation. And therefore, I was wondering if in the research plan, it is also possible to include the recommendation of the International Society for Forensic Genetics, and the article with the recommendation is in our package related to one of the complaints that we have reviewed today. And basically, I think it's important to consider because we have to distinguish. One way is to evaluate whether a laboratory has to revise the policies on how to handle procedures to minimize, reduce, control, well, maybe not control, but reduce or suppress contaminations, and that's one thing. But here, the marker Sharpie issue here can be perfectly be used as a defense line. And therefore, I think that the recommendation of International Society of Forensic Genetics document, they will be used to inform on how to set up a study that actually could be used in court as a support in case a defense would decide to use this defense line. Thank you very much.
Dr. Coble.
Yeah, certainly, Dr. Bazzini, I think that the eventual plan is to perhaps try to even publish this work to make it available. And again, we're certainly very open to being concordant with what the current best practices are from the ISFG and other organizations as well.
Okay, anything further? All right, let's move to item number 6, the discussion of the status of the crime lab laboratory accreditation program.
For our reported accreditation activities, communications, and reports this quarter, just to summarize, we had 4 surveillance document reviews and successful continuations of accreditation this quarter. One of those, we had Dr. Coble and Dr. Zemak review the nonconformities for us, and I believe that they had no follow-up questions on that one. We also had one lab, the Houston Forensic Science Center, achieve AR 3181 Property and Evidence Accreditation. So we congratulate them on that achievement. We had one laboratory reassess and renew their accreditation. We had one laboratory report an interesting DNA issue that they resolved. We had one laboratory report the accidental removal of testing for metal on objects and lead in their crime scene and firearms unit issue. And I think that covers the accreditation reports for this quarter. Did anyone have questions or follow up on anything in that memorandum? All right, moving on to our proficiency testing summary memo. This is where we summarize any reported non-consensus proficiency testing results. And we divide these into 6 or 7 different categories for you all. We had 2 reported non-consensus results in the category of method not used in casework. 6 of them were answer outside of validated reporting limits. 4 of those were the test provider or manufacturer had an error. 3 of them were simply clerical or data entry mistakes by the person taking the test. And 2 of them were from the same proficiency test in the same lab where the results may have impacted the proficiency of the actual person taking the test and required further root cause on. And those were related to a bloodstain pattern analysis PT from the Montgomery County Sheriff's Office. And I think Robert's going to give us a little bit more detail on that one because we had a call with the lab.
Yeah. There are 2.
Robert, can you speak up? I'm sorry.
There are 2 blood pattern analysis non-consensus result. One involved a slight measurement issue that impacted the angle determination by slightly over 1%, and the laboratory is given an explanation of how that occurred. The other is a pattern recognition definition question, where the definitions share a lot of characteristics and no context is given. And even though this was not the consensus result, there's some indication that this might be appropriate as well. So we're working with the lab and with ANAB to make sure that that's addressed properly in the quality system.
And to be clear, the individual who had the non-consensus result on the pattern issue is a reviewer for the lab who's not in Texas, they're outside of Texas. So it's not one of the main analysts, but still, we had an extended conversation with ANAB about how laboratories should run down non-consensus proficiency monitoring results. And that is always informative to us. And in the context of that conversation, ANAB let us know that since they've changed their expectations on disclosure of non-consensus PT as well as disclosure generally of nonconformities, they went from 80 some odd disclosures to almost 900 in a 1 or 2 year period, just due to their changed expectations around disclosure. So that is a huge deal, and they said that essentially this was the way Texas was disclosing anyway because of the Forensic Science Commission, but now they've seen this massive increase in disclosure in all the other states. So I just thought I would share that because it was kind of astonishing to me how quickly small changes in ANAB's expectation changes everything.
I think the next item under accreditation is discussion on the rulemaking that we have before the commission today, the changes and clarifications to 651.7 related to pretrial testing.
So the change that you have before you, I just wanted to give some background because this is an issue that has a lot of interest in the criminal justice community. The commission, until fairly recently, historically recognized 4 accreditation bodies: CAP, the College of American Pathologists, ABFT for toxicology, ANAB, and A2LA. Most of the publicly funded labs are accredited to ISO standards by ANAB. So these are the labs, like many, excuse me, who are here today and are the labs that you see most of the disclosures, all of the disclosures on the agenda, are labs that are working on criminal case prosecution or doing retesting for defense. When we started implementing the license program in 2019, Redwood Toxicology, who was accredited under ABFT standards at the time, they approached us and said that as they were considering licensure, they realized that a component of the work that they were doing, and this is a large laboratory with multiple facilities, that the urine testing they were doing for community supervision and parole compliance was actually under CLIA certification. It's a certification by the Centers for Medicare and Medicaid Services, which is under the Federal Clinical Lab Improvement Amendments of 1988, so federal legislation. Redwood asked the commission to add CLIA as a recognized accreditation program, but it's not an accreditation program, it's a certification, so we declined to do that at the time. Redwood then explained that its contracts involve primarily referral of individuals for drug treatment services, and in some rare instances, those urine results would be used for revocation proceedings. And at the time, they suggested language for an exemption, which the commission adopted. And what it did was it extended the statutory exception for presumptive testing to confirmatory testing for purposes of community supervision. But at the time, we did not expressly delineate that we meant to include all of the types of activities that aren't related or are sort of certainly involved in the criminal justice system, but are not the casework that is done for case-in-chief type prosecution to determine whether an offense was committed or guilt or innocence in a criminal offense. So we adopted that exception, and then later, a couple years later, the commission started investigating expert talks and the hair drug testing that was done in the context of an alleged drug-facilitated sexual assault. So, as I said, that investigation involved the hair matrix. And that investigation involved a case where someone was on trial, so it was a case in chief type scenario. During the course of that, the commission issued a report that included findings of professional negligence and also professional misconduct. So it was a very concerning case, and that report is published on our website. CAP was the accrediting body for expert talks, and in the course of working through that investigation and report, we came to the realization that CAP accreditation was not the same in many respects as the ISO 17025 accreditation that we're accustomed to seeing from the publicly funded labs. CAP accreditation previously existed when DPS had the accreditation authority, and we inherited it when the legislature moved accreditation to the commission. So a few things that we noted at the time were that there was just a general lack of responsiveness to our requests for updates on their inquiries into the issues we had raised. We didn't realize they had been placed on probation for a period at all. And so that was something that took an extended period of time for us to become aware of. They allowed on-site corrections during audits for things that one would think would require a more thorough root cause or a more extensive remediation over time. So at the time, we removed CAP as an accreditation body recognized for purposes of criminal prosecution. And what we did was we sent letters out to all of the labs that were CAP accredited, and we said we are planning to remove CAP as an accrediting body recognized. However, our understanding is that the majority of the work that CAP labs do is urine testing in connection with community supervision type activities. Here are the existing rule-based and statutory exemptions. If you have any feedback, let us know. We also went to CAP directly and said, here are the rule-based and statutory exemptions. We believe most of your entities that do testing under your purview fall within this. And they agreed, and they understood why we were removing CAP, and they did not object to that. More recently, we became aware of the fact that some judges and attorneys in Harris County were concerned about whether the language in that exception covered pretrial diversion and pretrial bond type activities. And so this revision to the rule is intended to make clear that all of those types of activities, pretrial bond, pretrial diversion, community supervision, parole, and probation, that we mean to treat those all together as similar activity, where in Harris County and other counties in the state, urine testing is commonly used and done in bulk by those companies. So that is the purpose of this exception that is proposed in rule form before you. I would like to say that since we began this process, however, a number of criminal justice stakeholders, including the local partners, whether it be in prosecutors' offices, the defense bar, the judges, the community supervision and parole, community supervision, also pretrial services, all the counties handle this work in different ways. Some of them have multiple agencies that are in these contracts, some of them just have one, some of them do everything through TDC. It really depends on the jurisdiction. But they have raised to us the fact that they seemingly, I have yet to hear any dissent on this, Dr. Barnard, but they seemingly would prefer that the commission have some level of authority over these labs that are doing urine testing in those contexts. And so as part of the work leading up to this meeting, I think were the commission to adopt the minor edits to this exemption that make it clear that we intended to include pretrial bond and pretrial diversion, the next step would be actually to reach out to CAP to see whether there's a viable path forward to bringing them back within the commission's recognition of accreditation for the purposes of those types of activities. Now, there are a number of things I think we would need to do to assure ourselves that CAP understands the expectations that the commission has, and the same thing is true for the companies that are performing the urine testing. So the path forward is to reconsider adding CAP back in with some work that would need to be done. So the suggestion is that we move forward to clarify the exemption today and then come back with a proposal at the next meeting after having sought feedback from the affected stakeholders as well as from CAP itself. And I know there may be some comment on this subject and also comment from commissioners potentially.
Lynn, I had a quick question. You went out a little bit on my side. What was your recommendation at the very end, the last two sentences?
The last two sentences that I just spoke, I don't know if I'll get them quite right, but what I was suggesting is that we would talk to the affected stakeholders or local partners. So that would be, the entities of government that are responsible for contracting for this testing, as well as CAP, which we would need to talk to about our expectations, as well as the companies that are engaging in the contracting to make sure that we can come up with some oversight rubric that would give confidence to all of the stakeholders, including prosecutors, defense lawyers, judges in particular, because they're the ones that are faced with these revocation decisions. So that's the idea, is that we would come forward. I hope you could hear that, Jarvis. Was that okay?
Any other comment by the commissioners?
Or I'll be brief. I know Mr. Parsons will probably join me in this, and I wish we had more judges that would come to our meeting. That's okay. But no, you have individuals who are sitting on a bond with conditions. One of those might be your analysis testing. You up to say we're satisfied with that not being regulated or being questions about the process. I think we need to do consistent with our statutory mandate, do everything to raise the level of forensic science. So I concur with Sharpie said.
I have a question. So this is related, I assume, also to the, and I may have missed you discussing it, the AverHealth situation in which they're also testing for custody, for example,
Yes.
child protection, that sort of thing.
Yes, Dr. All
Great.
of that. We don't have jurisdiction over family law matters, but that is also work that is done in that group of laboratories. AverHealth or AverTest is among that group, yes.
Right, thank you.
And just to make sure, we don't have jurisdiction over community supervision in this space, correct?
Well, for presumptive testing, no, that's a statutory exemption. For confirmatory testing, yes, unless we pass an exemption. So the idea for today is to clarify the exemption to show that we intended to include pretrial bond, and then come with a proposal for April about how to bring CAP back under the list of accrediting bodies, which would have the effect of bringing all that testing done in the context of pretrial bond, bail, community supervision, parole, probation, and pretrial diversion, all back within the commission's jurisdiction for oversight purposes. And that would only be allowed for urine testing. Well, it would only be allowed for that type of testing. There is some question about oral fluids that I need to run down, but that's probably too much for today. But primarily they're doing urine.
And the labs that do this for pretrial bond, are they in-state or out-of-state? And what would be the impact on the number of licenses that they would need to get, let's say, if they were under the commission's oversight?
So they are all out of state, to my knowledge. I think we checked that, Lee. Yes, they're all out of state, and they would need to get licensed if they are accredited. That's the law. Now, we do have the de minimis licensure program, which depending on volume, they may fall within that, but they would need to take all the training, Michael Morton Act, all that stuff but they've done that before. So this would not be a surprise to them that we have that rule here.
That, when you say that, you mean all of the labs that do the urine testing?
Yes, sir. That are doing that work in Texas.
Because I was thinking, is this one of those situations where we talked about this in the context of the federal government when we granted them an exemption at some point in time because of they work in a bunch of different states and things like that. So is that more analogous to the situation or not?
So I think the appropriate place for them in terms of licensure, which would be the de minimis license. If they are not, if their volume, there's a rule that applies to this situation, Jarvis, so they're not doing the full licensure, and the fees associated with the licensure are dramatically different than what, say, Texas DPS or HCIFS or HFSC are subjected to. So that would be the place where they would fit, not a blanket if you are working in one of those labs. So what the rule is for the feds is that they are licensed for purposes of practice in Texas. And Dr. Bernard, that's just the way it went. Jarvis, I think you were here.
It was not a unanimous vote.
I remember that part.
So for these companies, there is already an existing program that we have that would, I think that they are familiar with already, that would apply to them.
Okay.
However, in this particular case, based on the information that we have in our packets, the volume of testing that we're talking about is actually very large. We're talking about tens of thousands of confirmations if the information in our packet is correct. Just wanted to point that out.
Yes, it is a lot of tests, but it's also all around the whole country. So whether the de minimis threshold is exceeded, it will depend, it will be lab to lab.
And do you know how many labs would be affected?
I don't know. Are you guys hearing Erica?
Do you know how many labs would be affected? Ballpark?
How many did we count?
I think we had like 7 that were.
7.
I'm not sure of those 7, which ones do this type of testing.
7, roughly 7. And leading up to this meeting, the majority of them have reached out.
Anyone else on the commission? All right, is there any public comment?
Good morning, my name is Madeline Nicolaides, and thank you for allowing me to comment on item 6C. I'm the Director of Harris County Pretrial Services, and we supervise over 20,000 people and complete thousands of drug tests annually, of which the majority are negative. In July of 2022, the Commission discussed the removal of the College of American Pathologists and the Substance Abuse and Mental Health Services Administration of the Department of Health and Human Services from the list of accrediting programs recognized by TFSC. Labs that were on the list at that time received a letter regarding the intent to remove CAP and SAMHSA from the list of accrediting programs and noted the exemption for confirmation testing. Our vendor, Advertest, did not notify us at the time of the proposed change. Unfortunately, vendors such as Advertest likely interpreted the exemption of confirmation testing as applicable to them, including for the purposes of pretrial supervision, community supervision. After reviewing this issue with other justice partners, our vendor and general counsel from the commission, it is clear that the consideration of the effect of a rule change that as it applies to pretrial monitoring was an oversight, and any reading excluding pretrial under the exemption was not deliberate. However, the most concerning part to me is that our justice partners were not made aware of the commission's plans to change the rule, which may have led to unintended consequences for multiple jurisdictions across the state for people that supervise pretrial. This has been brought to our attention by the media as well as other interested parties that have shown light on this issue. In the future, the commission may consider having an ad hoc committee or subcommittee of justice practitioners to review the rule changes and assess the impact on the justice community. I appreciate that the commission is considering a rule change today that explicitly addresses pretrial monitoring. In addition, I would like to ask the commission to consider allowing vendors who were previously on the TFSC list of accredited labs to provide evidence of their compliance with programs such as CLIA and CAP from 2022 to present, so as to acknowledge the TFSC intended to accredit programs during that time frame. I would like to add one more thing. You've mentioned several times pretrial diversion. I don't see diversion on here. So I would just note that you have.
It's in the rule.
Okay, it's in the rule. Okay, perfect.
Thank you. All right, so, did you want to say something? Okay. Is there a motion to adopt clarifications to section 651.7, subject to suggested non-substantive revisions from the Office of the Governor, Texas Register, and Commission staff?
So moved, Dr. Burr.
Is there a second?
I second.
All those in favor say aye.
Aye.
Opposed? Motion carries. All right, now to item 7. This will be the discussion of the updates from the Licensing Advisory Committee.
Yeah, so the Licensing Advisory Committee met yesterday. To give you an update on the number of licensees, we have 1,293 current licensees. We're expecting to renew between 2024 and 2026, 685 licensees. Yesterday at our licensing meeting, we addressed the rulemakings between C, D, E, and F that we'll discuss on our agenda item here. And we also discussed one issue that's come up in the past regarding the lack of availability of accredited firearms providers and access to defense experts of these. And Mark and I have discussed this issue, and I also talked with a retired firearms expert who was trying to do work for a defense expert in this area, and she just couldn't afford to get accredited. So this is an issue that's come up in the past, and I'm not sure, Lynn, if you want to give an update on what we discussed yesterday about that.
Sure, so on the agenda at LAC was this consideration of availability of firearms experts in particular. So in a lot of other forensic disciplines, experts who come in to take a look at the work that is performed by the laboratory, the main, accredited lab work, if they review that work, they can do that quite effectively with the case record and the data. They don't, in many disciplines, really need to take custody of physical evidence. And what we're understanding from the firearms community is that in order for them to do a good job of that review, they do sometimes need to take physical custody of the evidence and put it under a microscope to evaluate whether what is in the case record and report of the accredited lab is supported by what they are seeing when they look at the evidence under the microscope. Right now, the law says that 38.35 excludes anyone who is not accredited from being able to testify. Well, let me back up. Article 38.35 requires accreditation for the expert examination or testing physical evidence for the purpose of connecting it to a criminal action. And so I think what the LAC is going to do and what they decided to do yesterday was to consider this. And so I would expect that we will add it as an agenda item for next time to discuss what options there are for the lack of availability of defense experts in the firearms space.
Lynn, help my memory, I'm trying to think back, maybe 3, maybe 4 years ago. My memory suffered quite a bit, but we had an issue come up with documents and the unavailability. And I know we took action. Is that, am I correct?
Yes, so that's exactly what happened. So at the time, Keith Hampton was on the LAC and he raised the issue that in his cases, if he had a question document issue, there was no one in Texas that was accredited that could help him as an expert. And so at the time, the commission decided to take QD out of the accreditation requirement by rule. And it was, as Dr. Bernard said about the federal examiners, it was not a unanimous decision. I think we can put it on the agenda for next time to talk about what the various options are. But yes, it's the exact same issue. So your memory is solid, Mr. Dean.
Thanks a lot. Thank you.
Okay, the next item here is C, and if you all recall, we had a rule proposal to transition to birth month expirations of our licenses. So this is just the rule adoption that we're bringing before you. If you, the rulemaking process, we publish our rule proposals and then we bring them back before you. This is the adoption that we have to publish on the Texas Register related to birth month expirations.
All right, is there a motion to move to adopt changes to section 651.207 to 651.209?
I'll make the motion.
Is there a second?
Second.
All those in favor say aye.
Aye.
Opposed? Motion carries.
Okay, item D here, this is our crime scene rule. Yesterday, at our licensing advisory committee meeting, the committee discussed this rule and also took comments from the public and decided to ultimately recommend to this commission that we add to the crime scene processing components for component requirements the TCOL 2106 course as a component requirement. And what that results in is that we bring back a new proposal to our April meeting. So they're requesting that we reject this adoption today and bring back a new proposal for the crime scene rule in April. And so you'll see that change to your motion document, if you agree with that recommendation.
Is there any discussion? Or is there a motion to move to accept the recommendation from the Licensing Advisory Committee to reject the rule adoption and direct staff to propose the rule with the TCOL 21.06 course component added for crime scene processors?
Or so moved.
Second?
I second.
All those in favor say aye.
Aye.
Opposed? Motion carries.
Okay, for item E here, our document examiners rule, there weren't any changes from what you have in your materials. What we're doing is voting to adopt a rulemaking to elevate the education requirement for document examiners And this is a rule proposal, so you'll see the adoption on your next agenda. The education requirement elevates from a high school diploma to a bachelor's degree. And the recommendation from the LAC is that you all adopt this proposal today.
Any discussion? Is there a motion to move to adopt changes to section 651.202 and 651.222?
So moved, Dr. Carr.
Is there a second?
I second.
All those in favor say aye.
Aye.
Opposed? Motion carries.
All right, the final item here is our quality standards chart for employing laboratories of voluntary licensees. Yesterday, we reviewed this chart to add quality standards required of employing laboratories of document examiners. And we added all of those components you'll see in your meeting materials. So today, we're just asking you to approve those quality standards that'll be published on our website.
All right. Is there any further discussion? All right, is there a motion to approve the updates and additions to the required quality standards for employing laboratories of voluntary licensees posted on the Commission's website?
So moved.
Is there a second?
I second.
All those in favor say aye.
Aye.
Motion carried. All right, next is item 8, which is a discussion and vote on proposed rule adoption.
I just wanted to pause here and recognize Lee's hard work on making sure all of these very complex administrative rule adoptions are before you. We have to also go through every 4 years, is it, Vina, reassessment of all of our rules. And so this was a very rule-heavy agenda, as you can tell. And also thank you to Vina for helping guide us to make sure we do all those things properly. So I just wanted to stop and recognize their hard work.
Thank you. Yeah, I definitely couldn't do it without Vina, her help and guidance in reviewing all the nuances. So thank you, Vina. Thanks. Agenda item 8, Dr. Bernard?
Yeah.
Agenda item 8 is a rule adoption from a proposal you all adopted at 2 meetings ago. And this is an adoption related to the appeals process responsive to the 88 legislative sessions, SB 991 and HB 3474, which harmonize the Commission's appeals process for crime labs and licensees. So you'll see changes to all the rules, numbers that are listed on your agenda. So we're asking you all to adopt the rule adoption today.
All right, is there a motion to move to adopt the following changes to amend 651.3, 651.8, 651.11, 651.101 to 651.104, and 651.305 to 651.308, to add new sections 651.105 and 651.402, and repeal sections 651.105, 651.106, 651.216, and 651.309.
I'll make the motion.
Is there a second?
I'll second it if I don't have to repeat it.
All right, all those in favor say aye.
Aye.
Opposed? That motion carries. I don't want to repeat it either. All right, agenda item 9.
Agenda item 9 is another rule adoption, and this is for the rulemaking extending from the 88 legislative mandate for the Commission to adopt a timeline for laboratories to remove those elimination samples that they keep in their DNA QA databases.
All right, is there a motion to move to adopt new rules 651.501 to 503?
So moved.
Second?
I second.
All those in favor say aye.
Aye.
Opposed? All right, number 10.
Agenda item 10 is that 4-year rule review that we have to do every 4 years that Lynn was referencing. And the rule review is designed to ensure that the reason for adopting all of our rules or readopting them continues to exist. So you'll see this is the proposal, and then our next meeting will have the adoption on it.
All right, is there a motion to move to adopt the four-year rule review as described in the agenda item?
I'll make the motion.
There's a second?
Second.
All those in favor say aye.
Aye.
Opposed? Motion carries. Item 11.
Do you think we could just take a 5-minute break before, and then we'll queue up the PowerPoint and we'll get going?
All right, let's take 5 to 10 minutes.
10 minutes.
No more than 10 minutes.
Sorry.
All I do is highlight.
Yeah.
And I leave.
Yeah.
Which makes it
Really
So what is that?
I was laughing
I know when she called it, you're calling. Oh, let me tell you, trust me, my mind went there, like I went to the worst case scenario. Like, you know, somebody out there. That's all. Right, they're gonna do DNA on the whole and see. I wasn't.
No, it's hard. Yeah, hard to get away with the rest of it.
Yeah.
Am I interrupting the interrupting?
Well, you don't see out.
Yeah, I mean,
I was gonna actually do my silver here because I like to do good. Do you know?
Yeah. That's a bridge too far.
All right, let's get started again. Next item agenda is the update regarding the complaint 21.27 University of Colorado National Innocence Project on behalf of Nannon Williams.
So what I wanted to do here, because this has been a complaint that's been going on for some time, I wanted to give the commission a status update and also talk about the direction that we'd like to go in as staff, given the fact that we don't have a foundational review from NIST yet. And I know many in the community are waiting for that. For reasons unknown, even though we tested the clicker, it's not advancing right now.
Can you turn it off?
Off and on. Okay, I'll just, so, next slide. Okay. So just to refresh your recollection, in this complaint, the facts of the case are that it was a capital murder, excuse me, where the victim was shot in the head. Mr. Williams was originally sentenced to death, but the sentence was commuted to life in prison because of his age at the time of the offense. And the complaint alleges that analysts at the former HPD crime lab misidentified the caliber of a fired projectile recovered from the victim at autopsy. The lab reported the projectile was a .25 caliber projectile, and an analyst testified to that conclusion at trial, and then during post-conviction litigation, re-examination yielded that the true caliber was a .22. So that information has all been presented throughout the appellate process over time. And the complaint itself requests the Commission's guidance in setting appropriate limitations to guide Texas practitioners, and I assume practitioners in firearm and tool mark more broadly, but on analysis, reporting, and testimony. So one of the things that we've been waiting for and why this has taken a while is because NIST conducts these things called scientific foundation reviews. And the point of those reviews, and they've done a number of them, including on complex issues like DNA mixtures and including probabilistic genotyping, but they pick different areas and they do these foundation reviews. And the point of them is to identify the scientific foundations that support the forensic methods in a discipline, to document and evaluate the empirical evidence for reliability. So they're really trying to look at what data underlie the discipline as a whole, and then explore the capabilities and limitations of forensic methods, and identify knowledge gaps and areas for future research. So they've been working on this for multiple years, and it's been delayed multiple times. But they look at the entire body of literature, and they evaluate and sort of separate the research that they feel like is quality in terms of its design and reporting, and they really zone in and try to figure out what does that research yield about the method and what work is left to be done. So this is their description of the firearms work that they're engaged in and haven't reported on yet, but essentially it says that forensic ballistic experts can assess whether a specific gun was used in a crime by examining bullets and cartridge cases under a comparison microscope. So that's the claim of the discipline. That's what they say they can do. And the study is meant to document the foundations of the method and assess its reliability by looking at the literature on error rates in particular. So how often do examiners in the area error? So that's one aspect of reliability, and this is what they're focused on. So because we don't have that study, and because it's taken so long, I think staff's recommendation is that we go ahead and present a report without the foundational review. We could always do a supplemental report that adds the foundational review or refers to it as an exhibit. But I think we just need to move forward out of fairness to the complainants and everyone involved. And also because the forensic community, including the TACLIT, the TAFQAM, the practitioners, are looking forward to what we have to say. And they would like to know what we have to say about it. So I think a good starting point in Texas is to recognize the importance of the blind testing that's been done at HFSC in collaboration with CSAFE. So that's been an important tool for understanding system performance, at least in Houston, and acknowledging that but the labs can't do that type of blind program testing, development, or execution without additional bandwidth, dollars, resources, and assistance. Now, HCIFS has also done blind testing, and Mickey has talked to us about this and participated in meetings on the subject of expanding it to other labs. And she's impressed upon us how resource intensive it is to do it right, to do it well. And so learning that, hearing that feedback, I think we need to talk about in the report, the importance of expanding that and supporting it. Ultimately, the HFSC study shows that when the lab runs blinds through their system, and in those blinds, they know whether the firearm shot the projectile, whether it be a cartridge casing or bullet. The examiners perform well on conclusive decisions. So by that we mean they didn't make a call of elimination when the weapon actually fired the projectile, and they didn't make calls of identification when it did not. So if you think of it along a continuum, identification on one end and elimination on the other end, there aren't errors going between those two categories, but there's an entire range in the middle that the blind testing results show is important for consideration when we think about reliability of the discipline. So of the blinds that HFSC ran, the examiners reached inconclusive decisions in 40% of the comparisons. And of that group, 70% had ground truth of elimination. So what that means essentially is that sensitivity and specificity are reduced by the limitations of the assay. It's not about whether the examiners are making wrong decisions. It's about the fact that there's only so much information that appears by virtue of what this test does. So it's either by virtue of the limitations of the information they have before them, or the decision thresholds that examiners have historically been trained to use for either identification or elimination. So what HFSC observed is that inconclusive decisions have probative value, but they're predictive of different source. That's the bottom line. And that's actually consistent with other published literature, including recently published literature in this space. I should mention here that at the Academy meeting, Nobles is going to be presenting a bullet study that they did, a black box study. So Nobles and Austin Hicklin in particular and his colleagues have done all the major black box and white box studies, fingerprints, they've done a number of them, and they're going to be presenting one on bullets. And what Austin impressed upon me when we were speaking about it recently is that this is really the first study, certainly the first black box, that has looked at bullets and damaged bullets, which is more aligned with what people often see in actual casework. and not, pristine cartridge casings or bullets or things like that. So it'll be interesting to see the results of that study, which is going to be presented in February. So in terms of where we might go with the report, I think we need to think about foundational issues first, which is, how one reports what it is that we've learned through the research and through the blind testing in Houston and other places. And I just realized very recently this week that HFSC has been working on a reporting language to help articulate these issues more transparently than what reporting language has traditionally done in the discipline. So the commission might offer suggestions on reporting language which stems from the HFSC work with the feedback from other laboratories in Texas and other interested parties, so that we can try to help not just tell the community that the reports need more information, but to actually offer solutions for what that might look like. And then also, it's important to distinguish handheld tools from firearms, because handheld tool comparison, even though some of the principles are the same, these studies that we're citing that have been done, that they have not been done in that particular assay. So it's important to distinguish that. And then after having done the release of the Webster report, we realized, thanks to the work of a collaboration actually between the Institute at Sam Houston for Forensic Research, Training, and Innovation, I think I got that right, Research, Training, and Innovation, they held a sort of statewide Friction Ridge practitioner meeting in Bernie, Texas, during which they talked about the Friction Ridge report that we issued and specifically focused on a number of initiatives in the form of how to get more transparent and let the end users, defense attorneys, and prosecutors know a little more about what's being done in the actual casework. So in Friction Ridge analysis, for quite some time, one understands that certainly the best practice is to analyze sort of in a linear fashion. So in firearms analysis, it would be important, I think, for the community to embrace what Friction Ridge has embraced in this state by and large, which is that the tool marks need to be analyzed in isolation first, and then side by side in the comparison process, but that all needs to be documented so that the end users can understand what did the analysts see before they looked at the test fire and what did they see after. So in Friction Ridge, they have something called the gyro system, which is what Glenn Langenberg talked about in our Webster report. And that is, its purpose is largely documentation, so people can see what's being done more transparently. And it is certainly true that randomly acquired characteristic similarities might be found after you initially look at it, once you have done the comparison, but at least that part of it would be transparent to end users. And then photographic documentation and how that's done, I think probably labs are already headed in this direction, but the more photography we can do, I think the better it is for the case record long term. So treating photography requirements differently based on what the conclusion result is, I think is something that examiners are already getting away from, but we might talk about that as well. And then another thing we've seen in the firearms space over time, the last year and a half or so, is because the non-consensus proficiency results need to get reported to us now by ANAP standards, we've seen a lot of non-consensus, well, I shouldn't say a lot, we've seen a number of non-consensus proficiency monitoring results that the labs have asked for help in discerning what needs to be done. So AAB has certain expectations in this regard that have expanded over time, and I think we really need to speak to the idea that if an examiner gets a non-consensus result, what are the expectations about how that should be evaluated? If you remember, a big issue at Fort Worth PD was that they had examiners who were calling looking at the PT that was given to them by CTS and making an inconclusive determination at the end of the comparison. And the consensus results were not inconclusive in some of those. And so they had a policy that was, well, if the quality manager gets with the examiner who called it inconclusive and the examiner justifies their inconclusive, then it's not, we don't consider it to be not consensus. And that was sort of their general philosophy or general practice. And the problem with that is then you don't ever actually really know whether or not the non-consensus PT is an indicator of someone having a competency issue. If inconclusive is always okay, then what's the point of PT is really the question. Now, there may be times when it is appropriate and is justifiable, but not as a blanket policy. So that's something that we want to speak to here. And I don't think that most labs are doing it that way. And certainly they've been paying attention to meetings and understanding that that is, and I think ANAB's been very clear about this as well. So it's possible that the existing, we're seeing this in many disciplines, existing proficiency monitoring may not be entirely fit for its intended purpose. And if that's the case, then we may talk about potential ways to address that. But that would require probably some statewide efforts to get together on that. So other issues that we might cover in this report would be that consultations and disagreements need to be documented. That is something that's an accreditation requirement already, but we can pull from the Webster report on some of that. I already talked about the statewide meeting where we discussed Webster, but the same should be done for firearms and tool marks. This is the big one, bullet 3, that framing results in terms of probability, so likelihood ratios, is certainly more statistically sound, but the reality is that there's a lot of practical resistance to the idea of introducing likelihood ratios in firearms. That's something that a number of members of this commission have strong opinions about. So I do think that it used to feel impossible, and now I think there's a greater awareness nationally about why probabilities is actually a better way to express the associations than these sort of conclusive categories like identification or elimination. And then we often do this in our reports, but we may have some recommendations to OSAC about things that they need to be working on. One of them is this idea of conclusion scales and how the different disciplines need to be approaching that. That is underway. Work on that is underway at OSAC, and so we might speak to that. And then certainly the impact of emerging technology, including 3D microscopy, which to my understanding, although the microscopes are very expensive, they really effectively address a lot of the documentation issues because to my understanding, they're actually taking photographs as it goes. Is that a fair way to say it, people who know? The photography there's a lot more information that one can retain using a 3D microscopy approach than if you're using the traditional microscopic evaluation. So those are some of the things that we're thinking about. And I think the plan would be for staff to go ahead and work on a draft of that to bring to you all for April. But I wanted to put this sort of status update out there and to get feedback from members who are here. And certainly those who are on the panel will, review the draft and everything and have opportunity to comment once we get that done. But ideas that you might want to give us that were not on this PowerPoint, and then of course to hear public comment from those with interest in this area that are in the audience. So that's all I have.
Thank you, Lynn. Is there any comment, commissioners or public?
Hi, I'm Chris Fabricant. I'm from the National Institute. Hello, is it working?
Yeah.
Got it. Hi, I'm Chris Fabricant. I'm the Director of Strategic Litigation at the Innocence Project in New York. Thank you so much for holding this public meeting. A couple of things that I just wanted to highlight for the Commission just before you're considering this report, and I'm sure that it's probably part of the mix that you're considering, but just is that one thing that we see a lot in litigation is subclass characteristics, and that to be distinguished from individual characteristics, and the trouble that firearms examiners have between distinguishing those two is a major issue. One of the things that we also hear, and I was really delighted to hear about the photography focus, is that often you will get firearms examiners in particular that will come in and say that I don't take photographs because they can be misleading. And those of you who have seen these photographs will note that they are misleading, right? Because you can make almost any bullet look as though some of the stria match and focus only on the matching stria and not on potentially stria that would be potential exclusion. So I think in terms of photography, a full 360-degree review would be an important aspect of this so that jurors have all the information and not just what the examiner focused on. The examiner obviously will tell the jury why he or she did, but they would have all the information. One of the things that I think is really essential, and I just didn't hear the word Brady, but I'm concerned about being conclusives, right, are kind of dismissed by the firearms community as not being that relevant when we know that an inconclusive is diagnostic of an exclusion should be rating material. And when those are kind of not being reported out or this kind of evidence kind of being thrown away is particularly troubling. One other thing that I wanted to note about likelihood ratios and verbal scales associated with them is two things. I know that there's resistance in the forensic community generally to likelihood ratios. It does strike me personally, I'm not speaking for our organization, as a advance in the field to use likelihood ratios, but subjective likelihood ratios don't have empirical information. These are just putting numbers on a subjective opinion. The other issue that I want to highlight is that a lot of the verbal scales that are developed are just kind of invented, wordsmith, right? And say, oh, we're going to say, strong likelihood of identification or leaning towards identification, and we don't have any empirical data as to how jurors are actually interpreting that language. And so if you're going to do a verbal scale, I think we need to have some empirical information as to the way the jurors are actually interpreting that language. The last two other things actually is one is that I think that the distinction between handheld tools and the forensic and firearms analysis are particularly important because the variables at issue are completely different. We don't have things like arm angle, pressure, etc. So, and the studies on those are not necessarily relevant. And then last, I would just want to emphasize some of the emerging work coming out of the 3D technology. A lot of this is being conflated in litigation to suggest that uniqueness has been demonstrated or been proven, or that this is validating what the technique is being used for today. And we have to focus on the fact that 3D technology uses actual measurements and are using measurements in ways that are far beyond what are actually being kind of eyeballed today. So these are really two entirely separate assays. The 3D certainly seems to be the way of the future. The computers are doing it well, but they're also showing that the thresholds for declaring a match, where you're not going to have random matches in the universe, are much larger than what we're seeing in actual casework. In other words, you need more information than what is being used under the microscope. And then, so those were some of the major points that I wanted to focus this committee on. And I think that's it. So thank you so much for giving me the floor for a minute.
Thank you. Any other comments? So item number 12, the upcoming forensic development training and education project.
So we have had a number of very successful programs recently. We brought DNA TLs together in Waco to discuss activity testimony, which is a very hard subject. We did our DNA training for lawyers and judges at the Capitol, which was very well received. I think it went well. And that training will be made available shortly on the Institute for Research, Training, and Innovation at Sam Houston, so we're excited about that. And then anyone can access that for free from their website, public-facing website, so that will be great. In addition, we have a number of conferences coming up. I would suggest the main one that Lee has been chairing the jurisprudence section and putting a ton of work into is coming up, the Academy meeting in February in Denver. So we will be that. Those are the main ones. Lee, did you want to talk about any other issues? We're going to be continuing the work in DNA related training, planning to do a training on the Sharpie situation, the research that's being undertaken by UNT. Also, the rare allele HFSC disclosure to make sure we understand how people are dealing with that for StarMix. And then additionally, we're going to try to do alternating Zoom and in-person trainings in DNA, expanding the work that we did at the Capitol Auditorium alongside Judge Herbie to other disciplines. We just need to figure out what's next. So we have lots of ideas on that. So there's been a lot of forensic development and training work going on. Talking with the Texas Rangers about the possibility of a crime scene academy, which we're very excited about. And then Peter yesterday talked about workforce development, and I think he's on the agenda, so I'll let you talk about that. Peter's next.
Yes, say something.
Judge Herbie would like to say something. Can you get her the mic, please?
Is it on? Okay. Yeah, that conference we had at the Capitol was very successful, and we had about 300 people. It was great. Actually got some of the other members of the court to attend. But anyway, I will be in Denver, and I'm going to use that scenario that was used for that Capitol performance as part of my presentation. But I wanted to tell you one thing we're doing as a court, and I will present in Denver, is I'm going to resurvey. Years ago, after the NAS report came out, I surveyed. I was particularly happy, I guess I'll say, with the return I got when I surveyed the criminal judges in the state of Texas. And I asked them how many of them had read the NAS report. I knew they hadn't, but and it was long. How many had read the survey? And then I asked them a series of questions that were basically aimed at, do you really know what your role as a gatekeeper is? And we got a 26% return, which I've been told with surveys is pretty good. And the judges were honest, that made me happy. And they said they didn't know jack. So on resurvey, I can't talk this morning. I'm going to do new surveys with prosecutors, the defense bar, the judges, and some lab people, because I oversee the education grant for lawyers and judges of all levels, and oftentimes we are fortunate to work with Lynn and the rest of the people at the commission to include scientists and law enforcement. And I'm trying to, my theory of training with forensics has always been, and Barry Sheck and I had arguments about this at first, and he finally admitted perhaps I was right, that my theory when it's a science is that we all learn the science. What you do with it in your camp is what you do with it. But we all have to know about DNA or ballistics or whatever. So that's how we try to train. And I'm trying to fill in gaps now. So not only am I working on surveys, I'm also going to work on new predicate questions. I have some problems with those. So we will continue to work with Lynn, and we're going to do these surveys, and we're going And I'm also a senior advisor to CSAFE. Peter is too. And CSAFE is working on an algorithm with regard to bullets. And they're working on that, so it was very interesting. And the 3D microscope is pretty cool, and the pictures and, yeah. So, I'm on that board too. So we will continue to work and get the legal community somewhat up to speed. Okay, so thank you.
Thank you, Judge.
All right. Item number 13 is an update from Texas Association of Crime Directors.
Before Peter starts, I did hear from OCA that they're happy to help with survey development dissemination as needed. So they have new software.
I'm talking about.
Great, thank you.
Peter Stout, Texas Association of Crime Lab Directors, and Judge Kirby and I have already talked about distributing a survey within Tech Lab, so we're happy to help there. So let's see, this meeting, we had elections of president and new secretary, so I was elected president again. Sorry, Dr. Bernard, you're gonna get to spend the next 3 years admonishing me to keep it brief.
People are gonna watch, it'll be fine.
Our new secretary is Wynn Henson. We very much appreciate her willingness to serve in that capacity. One of the things I'd point out from this meeting, we have 67 members now between 22 agencies. We actually added 2 voting agencies with this meeting, with that being Harris County Sheriff's Office and Montgomery County Sheriff's Office. So Shelley Rossi here was helpful in getting those 2 agencies in. And she and I have already talked about trying to find some of the other forensic operations within law enforcement agencies around the state to try and get them into TAC Lab, because it's becoming evident this is an ever more important communication mechanism to get information from TFSC to laboratories and vice versa. So I think maybe this next year's been a bit of focus on trying to find those organizations, and Shelley's graciously volunteered to help with that. Probably the most significant conversation we had in the meeting was, like Lynn mentioned, about workforce development. Every lab in the state is struggling with it. Kind of rough back in the envelope survey of labs, we kind of range between turnover rates of about 12 to upwards of about 30%. With some of us having in individual sections, turnover rates upwards of 50% in individual sections, which this hamster wheel is killing us. So Lynn and I had a conversation with Senator Eckhart's office, and I chatted a little bit with Senator Colkert's office earlier in the day, yesterday, talking, because interim charge reports are due here in mid-February, but trying to seek maybe an interim charge hearing around workforce development issues for forensic sciences, at least in the Senate. Because we gotta do something about this. And conceptually, I think there's a variety of things of how we'd like to see the state maybe help with this. How do we get people that are new graduates or early career people closer to case ready? Typically, the estimates I use in a lot of conversations, I hear other laboratory directors around the country use, it costs us somewhere between $300,000 and $500,000 to build a new ANDIS. And it typically takes somewhere between 1 and 2 years. It is a long process. When we have somebody walk out the door, I basically watch $500,000 walk out the door, plus the work that they've done with delays in courts becomes vulnerable. Now, basically that entire delay in court could be something that we have to rework, and it just goes into backlogs. So this is an outsized, disproportionate impact on the entire system. So that, I think, is one of the big focuses we're trying to work on. And that, I think, is probably the high points. Was that brief enough this time?
You passed.
Okay. Thank you.
All right. Next, consider proposed agenda items for the next meeting. Any comments to that?
The firearms issue that we discussed earlier, and then Lee will distribute, post a draft agenda like we always do.
Okay. Item number 5, is there a motion to direct the staff to schedule the next meetings, future panel and quarterly meetings? So moved. Is there a second?
Second.
All those in favor say aye.
Aye.
Opposed? All right. Number 16, is there any further public comment? We've covered several different public comments, but is there anyone else? Okay. Hearing none, is there a motion to adjourn?
I'll make the motion.
Is there a second?
Jarvis.
Second. All those in favor say aye.
Aye.
Opposed? All right. Yeah, we're kind of slow on the adjournment.